Okay, we've gotten to the end of the divorce consultation series. And at the end of a normal divorce consult, in most circumstances, if not all, I'm going to talk to the person about a collaborative divorce. I'm going to explore the possibilities of doing their divorce collaboratively if they're going to go through a divorce. And I say that because I think it's important for people to make an informed decision regarding a collaborative divorce. And then based on some of the things that we're going to talk about, you're going to see that it's not an individual decision. Whether or not to file for a divorce is an individual decision. Whether or not to get a divorce is, for the most part, an individual decision. But whether or not to have a collaborative divorce, whether or not to do the divorce using the concepts of collaborative law is not an individual decision, as we'll talk about. So let me go through some quick hitting parts right here at the beginning to answer some simple questions. Is a collaborative divorce always cheaper than a non-collaborative divorce? No. Is a collaborative divorce always faster than a non-collaborative divorce? No. Is a collaborative divorce sometimes cheaper than a non-collaborative divorce? Sure. Yes. Is a collaborative divorce sometimes faster than a non-collaborative divorce? Yes, absolutely. So, like with most things in a divorce, at the outset of the case, you don't know what the answers are to how much the case is going to cost, how long the case is going to take. You don't know the answers to a lot of things because you don't know for sure what decisions you're going to make. You don't know what your spouse is going to do in the case. You don't know what your spouse's attorney, if they have one, is going to do in the case. And you don't know what the judge is going to do. And in a lot of circumstances, you don't even know what court you're going to be in. Depends on what county you're in. There are counties in Texas, in fact, a lot of them, where there's only one district court. But sometimes in those counties, the county courts handle divorces too. So sometimes you're going to know which court you'll be in, sometimes you don't. But even if you do, you don't know for sure what the judge is going to do. So like everything else in a divorce case, at the beginning of the case, there's a whole lot of unknowns. So let's go back to collaborative divorce and try to discuss it and figure out what it is and what it isn't and whether it's right for you. One of the things to know at the outset about collaborative divorce is this, and that is to understand what it is not. Collaborative divorce is not just another term for an uncontested divorce. Collaborative divorce is not just another term for friendly litigation. Collaborative divorce does not just mean that you are doing the case collaboratively, meaning that you're doing it amicably, that you're doing it in a way where the two sides are working together to come up with solutions rather than just a fight. That may be termed as handling your case in a collaborative fashion just by using that term as an adjective, but that is different than saying that you are doing a collaborative divorce or that you are in the process of a collaborative divorce. And why do I say that? Well, for there to be a collaborative divorce, you have to have a collaborative law participation agreement signed by the parties. And you have to have a collaborative law participation agreement signed by the parties' attorneys. So one of the quickest ways to know that you are not truly in a collaborative divorce, despite what you may have been told by your spouse, is that you haven't signed a collaborative law participation agreement. You don't have an attorney. Your spouse doesn't have an attorney. You can't have a collaborative divorce in the state of Texas without that collaborative law participation agreement. And to have that, both sides have to have attorneys. Now, you can get a case done amicably. You can get a case done without much argument. You can get what most people would consider to be an uncontested divorce done without either person having an attorney. But it won't be truly a collaborative divorce under the law of collaborative divorce in the state of Texas unless both sides are represented and that agreement has been signed. So, to have a collaborative divorce, you have to each have an attorney. And then typically in Texas, there are other people involved. Let's talk about what a collaborative divorce is and compare and contrast it with all of the things that we've been talking about in the other videos, which is a litigated divorce. That's what is important to understand about collaborative divorce. Collaborative divorce is not the opposite of a contested divorce. A collaborative divorce, if you will, is the opposite of a litigated divorce. So what you are doing in a collaborative divorce conceptually is all of those things that we talked about in the prior videos, all of the discovery that can be done, all of the hearings that can be held, all of the motions that can be filed, all of that is taken and shelved, and in its place, you have agreed with your spouse to get your divorce under the rules of collaborative law. And by doing that, what you're agreeing to is to have meetings instead of anything else. Now, it's not truly accurate to say you're going to have meetings instead of hearings, because you may never have a hearing even in your divorce case. If you handle a case using what we would consider friendly litigation techniques, then there's a chance that you're never going to have a single hearing in the case. You may have a prove-up hearing at the end. It depends on the court that you're in. But even that is not a contested hearing. That's just showing up and somebody basically reading through a list of questions and those getting answered and then the judge signing the decree. And a lot of courts these days aren't even holding those prove-up hearings any longer. So there's a good chance if you handle your case through the techniques of litigation, and if you do it in an amicable manner, that you will never have any hearings and certainly never have any contested hearings. But it is accurate to say that in a collaborative divorce, what you're doing is you're trading the possibility of having those litigation matters done, those litigation hearings done, those motions filed, the discovery done, all of that. You're trading that for a set of meetings. So let's back up a minute and go through who the people are that are involved in a collaborative divorce. If you watch TV shows dealing with divorce, what you'll see a lot of times are the people sitting in a room and coming up with an agreement. They may be arguing. There was a show on years and years ago called LA Law, and in that they would often show the family law attorney, the divorce attorney in the law firm sitting there with his client, and then the other spouse would be in the room with that spouse's lawyers, and it would just be the four of them, and they'd be talking, and then they would typically start arguing, and in some cases fights ensued and things like that. It made for good TV. But it wasn't very accurate in terms of what happens in real life. In a collaborative divorce in the state of Texas, typically what you have is lawyer-client, and then you have two other people involved. One is called the financial professional, and one is called the mental health professional. And right off the bat, I like to tell people when they hear mental health professional, a lot of people think that what that means is somebody that's there to psychoanalyze people. That's not at all what the mental health professional is there to do. Each of those two people really have two major roles in the case. Let's take the financial professional first. The financial professional is basically there to do two things in a collaborative divorce. One is to gather all of the information. Instead of having a battle or a competition or an argument or a disagreement or even a difference of opinion on what the estate of the parties consists of, you have one person, the financial professional, that both sides have agreed to use as the professional in the case. And that one professional then gathers all the documentation and everything that's needed to be able to come up with what the inventory is of the parties. Ideally, what you have is two people who already know what they have. They already know all I have to do is pull up these statements. It shows what's in our brokerage accounts. We have this real estate. We have these vehicles. We may have these collectibles. We may have some toys, boats, other real estate, investment property, businesses, things like that. And hopefully the people already know what they have. But oftentimes what happens is one person has a pretty good idea of what the estate consists of, and the other person has very little idea or no idea what the estate consists of. So the financial professional's job is to pull all of the information together and to come up with one inventory that will be used throughout the process to work from in coming up with the division of the marital estate. The second thing that the financial professional is there to do is to work with the people on their budgeting and work with the people on how much money they need to live, whether it's before the case is over, during the pendency of the case, or after the case is over. Now, you may be saying, well, what does it matter how much the people need to live after the case is over? Well, that's one of the things about collaborative divorce that makes it kind of unique, is that collaborative divorce is the opportunity to come up with solutions that are outside the box. They're beyond what the court is able to do. If you took the case to court, if you took the case to trial and you didn't settle, the judge is limited. As we've talked about in other videos, there are very strict rules for what the court can do with respect to spousal maintenance. By agreement, the parties can do whatever they want. And at the end of the day, that's what collaborative divorce is it's a methodology to come to an agreement. It's one form of alternative dispute resolution. So let's go back to who's there. Lawyer, client, financial professional, working with the people to pull together the data and come up with the inventory, and then working with the people to figure out what their budgets are while the case is pending and after the case is over with. Then let's turn to the mental health professional. The mental health professional is really there for two things. One is in meeting and one is out of meeting. So out of meeting, what the mental health professional does is meet with the people and try to come up with a parenting plan. If there are children involved, the mental health professional is the one that helps the parties, along with their attorneys, in coming up with a plan of what to do with the children. Who's going to have what rights with respect to the children? How are those rights going to be exercised? What's the possession schedule going to be like? Figure out where the child's going to live, where the child's going to be, where the child's going to go to school, all of those kind of questions. The mental health professional is there to help the people work through and come up with a decision on, an agreement on. And then the second thing that the mental health professional is there to do, and this is very important, is to run the meetings. So I keep talking about these meetings, and that's what collaborative divorce is it's a series of meetings. How many meetings? You can have as few as 2. I suppose you could arguably have as few as 1, although I've never heard of that. But I think 2 is generally considered to be pretty much the minimum. But normally you need to think of it in terms of probably a minimum of 4. There's certain structure that happens in the first meeting and the second meeting and the last meeting, and then how many meetings you need in between there just depends on the case, and it depends on the people, and it depends on what's in dispute and how complex the case is. So I've been in collaborative divorces that have involved a number of meetings that have lasted a long, long time, and I've been in collaborative divorces that have been fairly quick, just I think 4 meetings may be the minimum I've ever been involved in. And so they happened pretty quickly, boom, boom, boom. And then we had the final decree done, and then the people were over with. That's how the meetings go. The mental health professional is there to help run the meetings and to keep everybody on task and to make sure that everybody stays focused, because collaborative divorce does not mean everybody is getting along all the time. There can be a lot of stress. There can be a lot of emotions in a collaborative divorce. And the mental health professional is there at the meetings to make sure that everybody stays doing what they need to do to get the work done, to get the case over with, and that we're not just wasting time in those meetings. And then to call breaks if needed, to get people back together at the right time, and to make sure that the meeting progresses as it needs to. Let's talk some more about how long these meetings can be. Some mental health professionals and some teams, when they come together for the collaborative divorce, decide that they're going to have real strict rules on the meetings. They're going to say, hey, these meetings are going to be exactly 1 hour. We're going to start at X time. We're going to end at X time. Doesn't matter. Pretty much if we're in mid-thought, once the time is up, the time is up, the meeting's over, and we'll just have to reschedule other meetings if we need to pick up on that point later, which you will need to, because you have to conclude by finishing everything. You have to get to the finish line, and that's why you never know how many meetings it's going to take at the outset. But other teams, mental health professionals in particular, but really it's a combined decision of the professionals in the group and the parties. But the parties are leaning pretty heavily on the professionals to come up with this concept. And some teams decide that what they want to do is be flexible. Some teams decide that, well, let's aim to have a 1-hour meeting or a 90-minute meeting. But if we're making progress and if things are going along well, then let's continue to talk until we get to a stopping point, until we get to a natural stopping point for that day. That can then lead to meetings that go on for 2 hours, 2.5 hours, 3 hours. Some people think that's a really bad idea because then you have people that may be exhausted coming up with decisions. And other people think, no, that's a great idea because that way you're continuing to work as long as you're pushing the ball down the field and getting close to the conclusion or getting closer to the conclusion of the case. Once you've had whatever number of meetings you have to have and you've come up with a framework for an agreement, then the case finishes up very similarly to a litigated divorce in that somebody has to draft the decree. One of the lawyers will draft the decree, and then the other lawyer will review the decree, and they'll go over it with their clients in whatever manner they want to. And then oftentimes they all come together. The entire group comes together for the signing to make sure that it all gets done, that if there's any last minute changes, they can get done right then and nothing delays the process. And then the decree is submitted to the court, either using a prove-up hearing or without a prove-up hearing, depending upon the judge. And the judge signs the decree, and then the case is over with, just like any other case. Now, there may be follow-up work to do, like in other cases. There may be quadros that need to get entered to deal with retirement accounts, and there may be real estate documents and things like that. So there may be some finish-up work, but the end of the case in terms of the court is the same, really, as any other divorce case. Because again, as I said in the very first video, every divorce is a lawsuit. A collaborative divorce is a lawsuit, just as any other divorce is. Now, some of the things to know about a collaborative divorce that are important and can be very helpful, because courts these days, unlike years and years ago when courts would allow cases to linger for a long amount of time. Back in the olden days, it was not unusual for cases to drag out 2 years, 3 years, 4 years, 5 years. Nowadays, courts don't like to do that. Nowadays, courts like to get you over with. Either just dismiss the case for want of prosecution and say, okay, you're not moving fast enough, I'm kicking you out of my court, in which case you can refile and just be right back into court. But at least it keeps their docket clear is what they're trying to do. So courts don't like to let cases linger as they did in the olden days. And collaborative divorce is one of those tools that can be used to then go to the court and say, hey, judge, we've all signed this collaborative law participation agreement. We need you to, for lack of a better word, leave us alone so that we can work on this and not be setting hearings for us, and not be demanding that we come into court to do superfluous things that don't need to be getting done since we're all working together to get this case over with. And so then the parties or their lawyers are supposed to report back to the court at certain times and let the court know that they are making progress under the collaborative concept. And then at the end of the case will get resolved just like we talked about. So that's pretty much collaborative divorce. The question then arises, is collaborative divorce right for me? And that's something that you have to answer for yourself. But as I said at the beginning of this video, you can't answer it just for you. You have to have some pretty good idea of whether or not your spouse is willing to go along with it if you are interested in it. So if after hearing all of this on collaborative divorce, you say, well, I'm not interested in that. I want to just use the regular methodology, either because I think we can get it done more easily than that, or because I think it's going to be much more complex than that. I think we're going to have knockdown, drag out hearings. I think we're going to have to use all of those discovery techniques. I think we're going to have to take depositions and send written discovery and do all of those things. If that's you and you say collaborative divorce is not for me, I'm not that kind of person. I don't want to be sitting in a room with my soon-to-be ex-spouse. I don't want to be working this through with them. I'd rather just use all the tools that have been around for hundreds of years, if not longer. And I'm fine with that without using this newer concept of collaborative divorce. Okay, well then you know you're not going to be in a collaborative divorce because nobody can force you to be. And if you don't want to be, then you're not going to be. But if you have listened to this and think to yourself, collaborative divorce may be for me, well then you have to think, is this the kind of thing that my spouse would go along with? And again, if you think that through and you think, no way, they're not going to go along with this, they're not going to be willing to sit in a room with me, whatever your thoughts are, well, then you know that you're probably not going to be able to do one. You could still ask, you could still see about it. The one thing that I hate is when one side or the other hires a lawyer and then that lawyer stands in the way of a collaborative divorce or stands in the way of a case being done using the collaborative techniques. So what are those benefits? Well, one of the things historically that makes collaborative divorce make sense is that you can get those settlements, you can get those agreements that are beyond what a court can do or would be likely to do. One of the things we talked about in another video was a right of first refusal, and I mentioned that judges don't usually like to put that in a decree. But if you agree to it, you certainly can get that in there. Collaborative divorce would be a case where if you have children involved, I would expect there to be some form of a right of first refusal if the people are at all interested in that, but you're liable to get one that's much more detailed and handcrafted if you do it using the collaborative technique. So collaborative divorce is something that is generally done if both sides are willing to give. Maybe they want something beyond what the court can give them, and they're willing to give the other side more than what the court will do. If somebody on either side of the case says, I'm not doing anything unless I'm made to do it. I'm not going to give the other side one penny unless I'm made to do it. I'm not going to give them any of the estate unless I'm made to do it. I'm not going to give them any time with the kids unless I'm made to do it. If that's the kind of person you're dealing with, then there's a good chance that collaborative divorce is not the kind of thing that's going to work in that case. But if you're dealing with people who are willing to sit in the same room and try to work through it, then collaborative divorce can be very good for people who want to maintain some kind of relationship after the case is over with. Everybody's different. Some people don't get along at all after their divorce. Other people get along better after their divorce. And so one way to have some hope of getting along better after a divorce is to do it through the collaborative process and work through all those things and work through a lot of the feelings with the help of that mental health professional in the room with you as you go through it, so that at the end of it, you've to some extent made a business decision and in some ways as a tool of estate planning. So the divorce becomes more about how are we going to live separate lives? How are we going to take care of our children? How are we going to divide all of this property and get on with our lives without having a sworn enemy out there that you're going to be dealing with? If you think collaborative divorce is right for you, I would urge you to find an attorney that you can talk to about it that's not going to stand in your way. In my opinion, what you don't want is somebody who is on either side of the spectrum. If you have somebody that just doesn't do collaborative cases and so they won't represent you and they say, well, I'm just going to have to send you to somebody else because I won't do a case collaboratively. Or they more likely just try to talk you out of it because they don't want to do it or don't know how to do it or whatever. Then I would encourage you to find an attorney that will talk to you about it with an even-handed approach, not try to talk you into it, not try to talk you out of it, simply talk you through it and help you determine whether it's right for you. One of the things that you have to have, in my opinion, for a collaborative divorce to work is the basic ability to trust your spouse to be accurate in what they tell the financial professional and the mental health professional. If your spouse is the kind of person that absolutely cannot be trusted, somebody that's going to hide documents, somebody that's going to hide evidence, somebody that's not going to be candid and turn over things, then in my opinion, you may not have a case that would work in the collaborative context. And one of the things that you need to know about collaborative law is this. One of the kickers to it is this. In a collaborative case, either side can decide at any point that they're going to opt out of the collaborative process. And if either side decides while the case is going on that, hey, I don't want to do this case collaboratively anymore. I'm either mad at my spouse now, or now I don't think I can trust my spouse, or I just don't think this is going very well, or I think it's taking too long, or I think it's whatever. I don't like the professionals that are being used. For whatever reason, there doesn't have to be a reason. Either side is allowed to opt out of the collaborative process, which then puts the case back in the litigation model. And if that happens, then both sides have to get new attorneys, and not just new lawyers at the same law firm. They have to get new lawyers and new law firms representing them, because the same lawyer cannot be in the case when it is a collaborative case, and then after it falls out of collaborative, and the same law firm cannot represent the people when it's in the collaborative process if it then falls out and goes back into the litigation model. So that is not all there is to know about collaborative divorce by any means. Another little tidbit I'll give you is this: you can have a mediation within a collaborative divorce. Some people don't understand that, and oftentimes you don't need that, but there are times when in a collaborative divorce, you get to an impasse, and rather than have the case drop out and go back into litigation where things can then get really ugly and messy and overly expensive for no reason, you can then bring in a mediator and mediate within the collaborative process and finish the case up collaboratively. So I hope this has helped you to understand collaborative divorce and hopefully decide whether or not it's something that might be right in your case. If you even think it's a possibility, I strongly encourage you to talk to an attorney that, again, will be even-handed and discuss it with you honestly and try to do what's in your best interest.